Well, hello, everyone, and welcome to Uncivil Law. And for today's stream, we've got count them, six U.S. Supreme Court decisions all at once. All my Christmases are coming together at once. It was a day off, and the Supreme Court's like, that's okay. You may not have some trial court, but we've got you covered. How would you like some Supreme Court? Hell yes. Hell yes, I'd like some Supreme Court. Just inject it into my veins. And that's exactly what we're doing, and I am here for it. It's awesome. And I'm so thrilled to cover this with you, and we will cover that as we go. So let's go ahead and get started. We turn our attention to the first such case, Blom Bank Sal versus Honickman et al. Great. That's a cool name. All right. Plaintiffs who are victims and families of terrorist attacks carried out by Hamas between 2011 and 2001 and 2003 sued Blom Bank Sal under the Anti-Terrorism Act for allegedly aiding and abetting attacks by providing finance services to Hamas. Okay. Blom argued the complaint failed to state a claim, and plaintiffs repeatedly affirmed they would not seek to amend their complaint if it were dismissed. The district court dismissed the complaint with prejudice, finding plaintiffs did not adequately allege that Blom had the requisite general awareness for aiding and abetting. So, fair enough, right? You have to be aiding and abetting. You have to be aware that you're doing that in some sense, right? That's just generally true in criminal law, right? It's not a conspiracy unless there's agreement, and it's not aiding and abetting unless you know you're facilitating it. You know, perhaps the stupidest example I can think of off the top of my head would be, you're a taxi cab driver and you get a call to drive someone someplace, and you do. And the place they want you to drive them to is a bank. And so you drive them there and, you drop them off as one does. And he says, hey, would you mind waiting for me? I'm coming right out. And it'll just be a couple minutes, I'll pay you for your time. And you're like, okay, sure, why not? So you keep the meter running as you do. The guy goes in, it takes, 15 minutes. He comes out, everything's calm. And he's like, okay, I'm ready to go home now. And so you drive him. And it turns out while you were doing all that, he was robbing the bank. So if you didn't know that, then you can't be aiding and abetting because you didn't know. You have to have some awareness that you're facilitating a crime. So yeah, or you just rented the car to the guy. I'd like to rent a car. Oh yeah, we're Avis. We rent cars. I'd be happy to rent you a car. And it turns out he used the car for the bank robbery. Yeah, unless you know that, again, not so much with the aiding and abetting. So fair enough, you have to show that they had awareness they were facilitating. Cool. That makes sense to me. So the district court says the plaintiffs did not adequately allege that you had the awareness for aiding and abetting. Okay, fine. The court denied leave to amend because plaintiff had declined several opportunities to amend and failed to identify additional facts they could allege. Okay. The Second Circuit affirmed the dismissal, finding that even though the district court had applied too stringent a standard for general awareness element, plaintiff's claim still failed under the correct standard. So exactly what does it mean to have awareness is, of course, a legal question, right? What does exactly that mean? And the district court required more than is necessary to have awareness. But the Court of Appeals was like, well, even under the correct standard, they still don't have enough awareness. So you got the law wrong, but not in a way that changes the result. Okay, fine. Following the affirmance, plaintiffs returned to district court and moved under Federal Rule of Civil Procedure to vacate the final judgment so they could file an amended complaint to meet the clarified standard. The district court denied the motion, ruling that Second Circuit's clarification did not constitute extraordinary circumstances required by the rule, and that plaintiffs' prior deliberate choices not to amend counseled against relief. On appeal, the Second Circuit reversed, holding that when a party seeks Rule 60B relief to file an amended complaint, district courts must not apply Rule 60B6's extraordinary circumstances standard in isolation, but must instead balance Rule 60B's finality principles with Rule 15A liberal amendment policy. Okay, so this basically gets into when can you amend your complaint, and can you amend your complaint after final judgment? Is that okay? Can I amend it even though there's final judgment against me? And the Supreme Court's like, well, at least the lower court was like, there's an issue here relating to this, how these rules interact. Okay. So what is the relevant standard? Relief under 60B6 requires extraordinary circumstances, and the standard does not become less demanding when the movant seeks to reopen a complaint to amend the complaint. A party must first satisfy Rule 60B before the liberal standard can apply. Yeah, that makes total logical sense to me, right? There's a standard to amend your complaint in general, but there's also a standard for what happens after a final judgment. So you have to get past the final judgment issue. So you do have generally fairly liberal ability to amend your complaint. It's not infinite, but there is generally the liberty to amend. But if there's been final judgment against you, there's a separate rule for that, and you have to show extraordinary circumstances. So you can't use the rules relating to amending to get around the rules relating to final judgment. You need to get past the final judgment hurdle first. Yeah, that makes total logical sense. Rule 60B6 is a catch-all provision that provides relief from final judgment for any other reason that justifies relief beyond specific grounds. So there's a whole bunch of reasons that we can grant relief, and also, if justice requires. The text and structure of Rule 60B makes clear the catch-all provision is only available in narrow circumstances. Yeah, I mean, this is meant to be a little used relief valve, right? It gives you reasons, and then also, by the way, any other reason. But that's meant to be interpreted narrowly because we prefer finality of judgment. So it's possible, but not preferred. 60B6 covers grounds not already covered by the preceding 5 paragraphs, and a broad interpretation would impermissibly circumvent the time limitations of those paragraphs. So if we interpret it broadly, it would sort of undo what 1 through 5 were trying to do. The court has consistently held relief under 60B6 requires extraordinary circumstances, as first established in some other case and reaffirmed. This strict interpretation is essential to provide finality of judgment. Yeah. So, you can appeal a judgment. That's what appeals are for, right? So if you get final judgment from the trial court and you're unhappy, you can certainly appeal. You can do that. But if the upper court says, you know what, it's fine. If you want to now reopen your case anyway, having lost your appeal, you know what I'd really like to do? I'd like to reopen my case anyway. Yeah, it's gonna be pretty extraordinary. No surprise, right? No surprise. It is possible under some extraordinary reasons, but it's not something we're looking to do every day. I mean, completely. Yeah, that's all that stuff. The Rule 60B6 standard does not change when the party seeks to reopen to amend. Yeah, it doesn't really matter why we're reopening. We just have to reopen. I want to reopen for the purpose of amending my complaint. Yeah, but you want to reopen. So we have to get past that hurdle. In that circumstance, satisfying Rule 60B6 necessarily precedes the rules relating to amending the complaint. First, you have to reopen. Then we can talk about whether or not you can amend your complaint, which is a separate thing. Rule 60B and 15A apply at different stages of litigation and require separate inquiries. Rule 15A2's direction the court should freely give leave when justice requires governs pretrial amendment, but does not apply when a case is closed following final judgment. So again, you have the opportunity to amend, but yeah. A party seeking Rule 60B relief must demonstrate extraordinary circumstances regardless of what they intend to do. The Second Circuit's balancing approach is not consistent with Rule 60B6 and this court's stringent precedent because it improperly dilutes Rule 60B6. Yeah, I mean, there's been a final judgment and everything. And you want to reopen, after final judgment? Yeah, it's going to take a lot. Plaintiff's argument the Second Circuit approach is consonant with both 60B6 and its court's precedent are unpersuasive. Balancing the strict standards of Rule 60B6 against the more relaxed standards of Rule 15 necessarily weakens the former and thus incompatible with the court's long line of precedent. Facts. It's like you're not even reading Rule 60, man. A different case does not suggest otherwise. A different case dealt with Rule 59E, which does not threaten the finality of judgment to the same degree 60B does. So Rules 59 might have some rules here, but, whatever. Foreman dealt with Rule 59, which does not threaten finality of judgment to the same degree. Thus, Rule 59E circumstances is not required to show the same extraordinary circumstances. So you might be able to get relief for some other reason, under some other circumstances, but yeah. The Second Circuit's disposition of the case was incorrect. District Court's 60B rulings are reviewed only for abuse of discretion. The District Court's determination plan failed to demonstrate any extraordinary circumstances warranting relief under 60B6. Both applied the correct legal standard and provide substantial justification for the conclusion. The District Court's justifications for decisions aligning with established Rule 60B doctrine that intervening legal developments rarely constitute extraordinary circumstance. Yeah, just because the law changed on you is not extraordinary. And the extraordinary circumstances must suggest the movement is faultless in the delay. That too. Thomas delivers an opinion in which everyone joins in a 9-0 opinion. So everyone agrees. Yeah, that makes total logical sense to me. Excellent. Great. All right, cool. Let's do another case. We turn our attention to the case of C.C. Devas versus Antrix. Devas Multimedia Private signed a satellite licensing agreement with Antrix, which is owned by the Republic of India for use by its Department of Space. But when the Indian government later determined it needed more satellite capacity for itself, Antrix terminated the contract under force majeure clause. The parties proceeded to arbitration. After unanimously concluding that Antrix had breached the contract, the arbitral panel awarded Devas $562 million in damages plus interest. Devas then petitioned the United States District Court to confirm the award. The District Court confirmed the award and entered a $1.29 billion judgment against Antrix, presumably because of the interest. In the meantime, the Ninth Circuit reversed, finding that personal jurisdiction was lacking. Okay, under the Foreign Sovereign Immunity Act, personal jurisdiction over a foreign state shall exist whenever an immunity exception applies and the foreign defendant has been properly served. Ninth Circuit did not question that Antrix is a foreign state under the Foreign Service Immunity Act, that the immunity exemption applies, and that Devas effectuated proper service. Yet, bound by circuit precedent, the panel explained the act imposes an additional requirement. Okay, personal jurisdiction under the Foreign Service Immunity or Foreign Sovereign Immunity Act, also requires a traditional minimum contact analysis as set forth in International Shoe. I buy that. That makes sense. Just because you're immune or not immune, you might still have to get to the issue relating to sufficient minimum contacts. I buy that argument. That makes sense. Applying that standard, the court concluded it could not exercise jurisdiction over Antrix because Antrix lacks sufficient suit-related contacts within the United States. Okay. A personal jurisdiction decision from the U.S. Supreme Court. Exciting. Held. Personal jurisdiction exists under the Foreign Sovereign Immunity Act when immunity exception applies and services proper. The Foreign Sovereign Immunity Act does not require proof of minimum contacts over and above the contacts already required by the Act's enumerated exception to foreign sovereign immunity. Interesting. Not necessarily obvious. I at least in my mind, it's not necessarily obvious. I'd have to dig into it a little bit more to see whether or not I agree with that in the first instance. But that's the Supreme Court thinks there's jurisdiction because of the Foreign Sovereign Immunity Act. That's interesting. Okay. The Foreign Sovereign Immunity Act personal jurisdiction provision imposed two substantive requirements. First, the district court must have subject matter jurisdiction, which the Foreign Sovereign Immunity Act grants whenever there's an enumerated immunity exception applies. Second, service must be made under the Foreign Sovereign Immunity Act's specialized service of process rules. So they're basically like the Foreign Sovereign Immunity Act actually itself set up rules that therefore go beyond like standard minimum contacts because it's created by a statute. I'm like, okay, that sort of makes sense. Also, it sort of makes sense because you're dealing with a foreign entity, and Congress therefore has the power to choose which court has jurisdiction because you're dealing with a foreign entity. So Congress made a choice that allowed for that. So that makes sense. That is not what the Ninth Circuit said, Holmes. That is unduly reductive. The Foreign Sovereign Immunity Act personal jurisdiction provision imposes two substantive requirements. First, the district court must have subject matter jurisdiction in which the Foreign Sovereign Immunity Act grants whenever enumerated immunity exception applies. Second, service must be made under the Foreign Sovereign Immunity Act's specialized service process rules. When the criteria are satisfied, the statute declares that personal jurisdiction shall exist. Accordingly, the most natural reading of the operative text is that personal jurisdiction over a foreign sovereign is automatic whenever an immunity exception applies and service of process has been accomplished. Notably absent from the provision is any reference to minimum contacts, and the court declined to add what Congress left out, as the Foreign Sovereign Immunity Act was supposed to clarify governing standards, not hide the ball. Fair enough. Of course, the Foreign Sovereign Immunity Act immunity exemptions themselves, requiring various degrees of suit-related domestic contact before a case must proceed. But to the extent these exceptions satisfy international shoe, it's because the exceptions Congress wrote happen to meet the standard, not because the Act's personal jurisdiction provision secretly incorporated it. Okay, I buy that. So basically, the Act itself provides the grounds for suit, and those grounds may, in some situations, be coextensive to international shoe, but that is merely coincidental. So all you have to satisfy, you do have to satisfy certain criteria, but those criteria may not necessarily be the same as traditional minimum contact analysis because it's provided by a statute. The Act structure reinforces the reading. The Foreign Sovereign Immunity Act comprehensively regulates the amenability of foreign nations to sue in the United States. The immunity and jurisdictional provisions form the foundation of the comprehensive scheme, and Congress deliberately tied them together. Whenever an exemption applies, the Foreign Sovereign Immunity Act strips immunity and grants jurisdiction. Reading an additional minimum context requirement into the only one of FISA's tethered immunity and jurisdictional provisions would weaken the link Congress forged and create a gap of otherwise comprehensive foreign framework. Yeah, that makes sense to me because, again, especially you're dealing with a foreign entity. And so it certainly feels like in the first instance that Congress could therefore choose which court would have jurisdiction. So you don't need to satisfy, for the same reason you might for a U.S. citizen or a domestic company because they're foreign. And so, like, Congress can make the choice. Yeah, that makes sense. Ninth Circuit's two contrary arguments cannot override the plain meaning of the Foreign Sovereign Immunity Act personal jurisdiction. First, the fact that one of the immunity exemptions contains language resembling minimum contacts says little about whether jurisdictional provisions located elsewhere provides it. So again, there might be some language that mirrors international shoe, but that is a choice Congress made and is not indicative of other choices Congress made. Second, the legislative history cited by the Ninth Circuit shows only Congress believed the context set forth in the Act, then existing immunity exemptions satisfy due process, not that personal jurisdiction silently includes atextual minimum requirements. The alternative arguments that the Fifth Amendment itself requires a showing of minimum contacts, the claimant issue do not fall within the Foreign Sovereign Immunity Act arbitration exception, and the suit should not have been dismissed, should have been dismissed under forum non-convenient, were not addressed below. The court declines to address them in the first instance. So maybe there's a Fifth Amendment argument to be made under basically due process. Although you didn't make that argument, and we're definitely not deciding it today. Alito delivers an opinion for a unanimous Supreme Court. Okay, fine. I have no problem with that either. Next case. We turn our attention. Let me resettle this and make it a little bit bigger. There we go. We turn our attention to Catholic Charities Bureau versus Wisconsin Labor and Industries, in which the Supreme Court writes the following. Wisconsin law exempts certain religious organizations from paying unemployment compensation tax. The relevant statute exempts nonprofit organizations organized primarily for religious purpose and operated, supervised, controlled, or principally supported by a church or convention of associations of churches. Petitioners, Catholic Charities Bureau, and its 4 sub-entities sought exemption as organizations controlled by the Roman Catholic Diocese. I mean, it does suggest it is kind of in the name, right? I mean, it's Catholic Charities Bureau. And they're like, our argument is we're religious because we're controlled by the diocese. It's like, yeah, that seems plausible. The Wisconsin Supreme Court denied the exemption, holding petitioners were not operated primarily for religious purposes because they neither engaged in proselytation nor limited their charitable services to Catholics. Okay. And the Supreme Court has nothing, the fact that the Supreme Court has nothing more to say about this fact pattern, to me, is pretty hilarious. When the Supreme Court basically spells out the entire fact pattern in 3 sentences, you know you're in trouble, man. Holy shit. Hell, the Wisconsin Supreme Court application of the relevant law to petitioners violates the First Amendment. The First Amendment mandates government neutrality between religions and subject to any state-sponsored denominational preference to strict scrutiny. The Wisconsin Supreme Court interpretation of the relevant law imposed a denominational preference by differentiating religions based on theological lines. Petitioners' eligibility for the exemption ultimately turned on inherent religious choices, namely whether to proselytize or serve only co-religionists in the course of charity work, not secular criteria that happen to have a disparate impact. Because of the regime's explicit differentiates between religions based on theological practices, strict scrutiny. Yeah, yeah. These guys aren't proselytizing, so they're not really a religion. Yeah, that's no. The state argues that when it comes to religious accommodation afforded by the government, courts should ask where the accommodation's eligibility criteria are the product of discrimination. No, that's not right. That's not the right standard. In support of that rule, the state draws on Gillette. Gillette, however, is an opposite. You don't say. Unlike conscientious objector status in Gillette, which was equally available to members of all religions, the Wisconsin Supreme Court's interpretation of the relevant law facially differentiates among religions based on inherent theological choices. The state next disputes the premise that petitioners were denied coverage because they do not proselytize or serve only Catholics in the course of performing their work. The state instead claims petitioners were excluded because they engage in no distinctively religious activity, meaning that activities that express and inculcate religious doctrine. That understanding of the Wisconsin Supreme Court ruling, even if assumed correct, cannot save the statute from strict scrutiny, because decisions about whether to express and inculcate religious doctrine while performing charitable work are fundamentally theological choices. Yeah, I mean, again, how much religion do we have to bring into this, right? I mean, it's like, yeah, you're telling us how to practice our own religion? That's nice. Lord. The relevant law as applied cannot survive strict scrutiny because the state has not met its burden to show the law's application is narrowly tailored to further governmental interests, compelling governmental interest at that. Wisconsin contends the exemption advances 2 principal interests. This should be real fucking good. First, it argues the law serves a compelling state interest in ensuring unemployment coverage for its citizens. The state, however, has failed to demonstrate that the theological lines drawn by the statute are narrowly tailored to advance that interest, particularly as applied by petitioners. Indeed, petitioners operate their own unemployment compensation system, which provides benefit largely equivalent to the state. The distinctions drawn by Wisconsin's regime, moreover, are under-inclusive, exempting religious entities that provide similar service, that is, without proselytizing or serving only co-religionists, when the work is done directly by the church. Second, the state asserts an interest in avoiding entanglement with employment decisions based on religious doctrine. Resolving misconduct disputes for employees tasked with inculcating religious faith, the state argues, may require to decide whether those employees comply with religious doctrine. Cute. The lines drawn by the exemption, however, are over-inclusive in relation to that interest, for they operate at the organizational level, covering employees that do and do not inculcate religious doctrine in equal measure. This poor fit between the state's asserted interest and decisions drawn cannot satisfy strict scrutiny. I think the Supreme Court just called you dumb in like 8 different languages. Does it burn? Does it burn? Do you need some salve for the burn? Because the Supreme Court's calling you dumb in just, yeah, oh my God. Sotomayor delivers an opinion for a unanimous Supreme Court. Yeah, that one's gonna hurt. That one's gotta hurt. That is not only were you wrong, you are incredibly stupidly wrong. You are dumb. You are dumb wrong. That one's gotta hurt. Someone's got to be feeling that today. That's rough, man. Woof. Next case. We turn our attention to Smith and Wesson versus Mexico, the country, in which we discuss the following. The Protection of Lawful Commerce in Arms Act bars certain lawsuits against manufacturers and sellers of firearms. As relevant, it provides that a qualified civil liability action may not be brought in any federal or state court, and defines the term to include a civil action or proceeding against a firearms manufacturer or seller stemming from criminal or unlawful misuse of a firearm by a third party. But the relevant law's general bar on these suits has an exception, sometimes called the predicate exception. That exception applies to lawsuits in which the defendant, manufacturer, or seller knowingly violates state or federal statute applicable to the sale or marketing of firearms, and the violation was a proximate cause of the harm for which the relief is sought. The predicate violation demands may come from aiding and abetting someone else's firearms offense. No shit. Yeah, I mean, if you are involved in a criminal, if you're involved criminally, aiding and abetting the criminal, like in a criminal sense, then no shit, we can sue you if we needed to clarify that. The relevant law itself lists examples, 2 ways in which aiding and abetting qualifies. When a gun manufacturer or seller aids or abets another person in making a false statement about the gun sales legality, or in making specific criminal sales. So again, this has to be like aiding and abetting a particular crime. Like this cannot be like some sort of global nebulous sense, right? This can't be I run a taxi company and sometimes people call my taxi company to take them to the bank for the bank robbery. It can't be, I run Uber and sometimes people, it can't be I run a rental car service and sometimes people take the rent cars in order to do a job, an illegal one at that. All right. It can't be aiding and abetting in some sort of like global sense of I have awareness that sometimes criminals use my products too. It has to be a little bit more specific than that. I have to be knowing about particular criminals or particular criminal organizations and doing things to facilitate them. not that there are criminals who exist who might use my services. Yeah, that's not going to work. My opinion on the Trump-Elon drama, I have no particular opinion, but thank you. I understand Elon's frustration, and I very much sympathize with it. But beyond that, I don't really have anything to say about it. And more broadly, because federal law provides that whoever aids and abets a federal crime is punishable as the principal, a gun manufacturer that aids and abets may itself commit the predicate exception. Yeah, because you are the principal. You're the same. So yeah. Here, the government of Mexico sued 7 American gun manufacturers, alleging the company aided and abetted unlawful gun sales that routed firearms to Mexican drug cartels. Yeah, this should be good, right? The basic theory of the suit is that defendants failed to exercise reasonable care. I don't have to keep reading, right? You guys know what the Supreme Court decision is, right? If you don't know what the Supreme Court decision is at this point, you are not picking up what the Supreme Court is laying down. We all know what they're going to say, right? Let's just get to the end of this thing. The basic theory of the suit is defendants failed to exercise reasonable care to prevent traffickers of their guns into Mexico, and so are responsible for harms arising there from the weapon's misuse. That theory implicates the general prohibition, so the complaint tries to plead its way into the predicate exception. Yeah. It alleges the manufacturers were willful accessories in unlawful gun sales by retail gun dealers, which in turn enabled Mexican criminals to acquire guns. And it sets out 3 kinds of allegations relating to how manufacturers aided and abetted the retailers' unlawful sales. The manufacturers allegedly supplied firearms to retail dealers, who they know illegally sell guns to gun traffickers, have failed to impose the kind of controls on their distribution network that would make illegal sales to Mexican traffickers. Oh, man. Yeah, man. Do we really have to keep reading? Suck it. And make design and marketing decisions intend to stimulate cartel members' demand for products, including, incidentally, the specific example. I'm going to screw this up a little bit, but was it like the El Jefe, like the Smith and Wesson made? I want to say it was Smith and Wesson. If not, forgive me. Smith and Wesson made, I think it was a 45 caliber gun, and they called the model the El Jefe. That was the name of the model. And because we called it the El Jefe, we were obviously trying to market specifically to Mexican cartel members. Seriously, that was one of the things that was in the lawsuit. The district court dismissed the complaint, but the First Circuit reversed, finding Mexico had plausibly alleged defendants aided and abetted. Held. Because Mexico's complaint does not plausibly allege defendant gun manufacturers aided and abetted, the lawsuit's dead. We appreciate your enthusiasm and all to try to get around the Protection of Lawful Commerce Act. We appreciate your enthusiasm. You know, Court of Appeals for the First Circuit. We appreciate your enthusiasm, but no. Federal aiding and abetting law reflects the view that a person may be responsible for a crime he's not personally carried out if he deliberately helps another complete its commission, incidentally, with knowledge that what they're doing is criminal. Because again, not only do I have to be deliberately helping, but I have to know I'm deliberately helping a criminal action. To aid and abet a crime, a person must take affirmative act in furtherance of the offense and intend to facilitate its commission. Or as Judge Learned Hand, Holla, stated, these requisites must participate in the crime as something he wishes to bring about and seek by his action to make succeed. He wants the crime to occur. He's trying to make it happen. That's aiding and abetting, man. Yeah. In elaborating on the demand, the court has developed several ancillary principles. First, aiding and abetting is most commonly liability for specific wrong acts, though broader liability for category misconduct is possible if a wrongdoer's participation is correspondingly pervasive, systematic, and culpable. So you can sort of get into a category of things, but you have to show they specifically aided and abetted a lot of specific things in the category to get to the category. So you have to still show the specifics. And then, like, if you get enough specifics together, then maybe the general, right? So this is also like used in RICO to some degree, right? This is like saying, like, oh, it's like, I didn't know about, this is very common in like a RICO or mafia kind of situation. Like, I didn't have any specific knowledge of any of these particular acts. Like, suppose the mafia boss, the mafia don, is being charged on a RICO. And suppose he gets up and says, I was not aware of these particular criminal acts. And suppose that's true, which isn't exactly like unheard of, because sometimes they go to some length not to know, right? They go to some length not to know about the specific criminal acts. So are you done? Well, not really, because you can still get there, although you have to do a little bit more work. If you can show the mafia don had specific knowledge of a group of related crimes, right? Let's suppose number rackets, to go old school, right? Let's suppose you can prove the mafia don had specific knowledge of specific number rackets that he specifically approved of and like had interaction with. If you can show like enough of these things to show like, okay, now he has knowledge of the entire like scheme, right? So we can broaden out. So yeah, you didn't have knowledge of these particular crimes, but you had knowledge of the genus. If you want to go like to a genus versus species thing, we can show you had knowledge of the genus and therefore had knowledge of the species, even though you really didn't. Basically, please stop committing crimes, in so many words. So yeah, you can get to the category as a thing if you can show enough instances of the specific to show that, they're not only aware of specific crimes, but as part of a overall scheme, I suppose, for lack of a better description. But you have to actually do that. All right, carrying on. All right. Second, aiding and abetting usually requires misfeasance rather than nonfeasance. So usually you have to do something rather than not do something, because, people, generally speaking, aren't required to do things. Absence an independent duty to act, failures, omissions, and inactions will rarely support liability. I would go so far as to say never, but the Supreme Court's going to be a little bit more cagey, but whatever. And third, routine and general activity that happens on occasion to assist crime, in essence, incidentally, is unlikely to count aiding and abetting. Routine and general. Again, this is sort of our car rental place example, right? I'm a car rental business. That is what I do. I'm a car rental business. I rent cars. And sometimes the people who rent my cars are criminals and are renting the cars for the purpose of committing crimes. They'd like to rob banks, and wouldn't you know it, their car's in the shop. So what do they do? They come to me, friendly neighborhood Avis, and say, "Hey, friendly neighborhood Avis, can I rent a car?" "You sure can." Can I get the protection? Can I get the insurance rider? I'm a little bit concerned about potential damage to this car. "No problem. I'll be happy to give you that insurance rider." Right? And it's like, even if I know that, like, from time to time this is going to happen, without specific knowledge of specific crimes, like, I'm still not responsible. Wouldn't you know it, we have a surprisingly robust bank robber base. Who knew? That was one of our market segments. But, without specific knowledge, what am I supposed to do about it? Yeah. Pressing on. Thus, for instance, an ordinary merchant, for example, our car rental business, does not become liable for criminal misuse of goods simply by knowing that in some fraction of case misuse will occur. Yeah, so just because I know some people rent my cars and, commit bank robberies, not so much. Jack says, if I rent a car for someone else and they commit a crime, you're on the hook. No, not without knowledge of that, you're not. Not without knowledge of it. No, you're not on the hook. Two of the court's case illustrate the principles. In direct sales versus United States, the court held that a mail order pharmacy could be convicted for assisting a small town doctor's illegal distribution of narcotics. The pharmacy had sold the doctor massive quantities of morphine, 5,000 to 6,000 half grain tablets monthly, versus a typical physician's 400 quarter grain annually. That does seem like a lot, right? Because 400 quarter grain is equivalent to 200 half grain. So that's 200 half grain a year versus 5,000 to 6,000 a quarter. Yeah, that's a little bit of a different number. Actively stimulate his purposes through special discounts and high-pressure sales methods, and continue these practices despite law enforcement warning. All this showing the pharmacist not only knew of and acquiesced in the doctor's illicit enterprise, but joined both mind and hand with him to make the accomplishment possible. Yeah. But let's see. By contrast, in Twitter, the court dismissed aiding and abetting claims against social media companies for aiding and abetting a terrorist attack carried out by ISIS. Although the plaintiffs there alleged that ISIS supporters used the company platforms for recruiting and fundraising, and the companies knew this, but failed to adequately remove ISIS content, that was not enough to make the companies liable for ISIS terrorist acts. At the most, plaintiffs alleged that the companies provide their platforms for general use, then stood back and watched as ISIS misused them. And more was needed for a provider of generally available goods and services to be liable for customer misuse. For example, the kind of conduct in direct sales. Absent that backdrop of law, Mexico's complaint does not plausibly allege defendants, manufacturers, aided and abetted gun dealers unlawful sales. To begin, the complaint sets for itself a high bar. It does not pinpoint, as most aiding and abetting claims do, any specific criminal transactions. Instead, it levels a more general accusations that all manufacturers assist in some number of unidentified rogue dealers in violation of various legal bars. To survive, it must be backed by plausible allegations of pervasive, systematic, and culpable assistance. Mexico's lead claim that the manufacturers elect to sell guns to, among other known rogue dealers, fails to clear the bar. For one thing, it's far from clear that such behavior without more could ever count as aiding and abetting. Wow. And in any event, Mexico has not said enough to make its allegations on this point plausible. It does not confront that manufacturers do not directly supply any dealers, and the complaint does not name alleged bad apple dealers or provide grounds for thinking that anyone up the supply chain acquires that information. What Mexico has plausibly alleged is only that manufacturers know of some unidentified dealers routinely violate the law, but describes this indifference rather than assistance, sufficient to the insufficient allegations in Twitter. Man. For related reasons, Mexico's second set of allegations that the manufacturers have declined to suitably regulate the dealers' practices cannot fill the gap. Of course, responsible manufacturers might well impose constraints on their distribution chains to reduce the possibility of unlawful conduct, but failure to do so is what Twitter called passive nonfeasance. Such omissions and inactions, especially in an already highly regulated industry, are rarely the stuff of aiding and abetting liability, and nothing in Mexico's allegations make them so. You are getting destroyed. Apparently, the Supreme Court woke up this morning and chose violence. That apparently is what they decided. They decided today. The Supreme Court woke up and chose violence because they are just destroying everyone, or at least destroying one side of every case. They are not holding back. Today we are pissed at one side, and we're going to tell you about it. Today is not nuanced day. Today is not, some mistakes were made day. Today is you are bad, you are dumb, and we're going to tell you you are bad and you are dumb in no uncertain terms, in clear legal language, and we're going to beat you until you die. That apparently is what the Supreme Court decided to do this morning, and I'm here for it. Finally, Mexicans' allegations about design and marketing decisions add nothing of consequence. Mexico focuses on the production of military-style assault weapons, but these products are widely legal and purchased by ordinary consumers. Manufacturers cannot be charged with assisting criminal acts simply because Mexican cartel members also prefer these guns. The same applies to firearms with Spanish language names or graphics alluding to Mexican history. What the fuck, right? I mean, seriously, this is the El Jefe thing all again, right? Because they called the model the El Jefe, or because they carved into the firearm a scene depicting a Mexican battle. What the fuck? Right? What the fuck? Yeah. The same applies to firearms with Spanish language names or graphics alluding to Mexican history. While they may be coveted by the cartels, they may also appeal to millions of law-abiding Hispanic Americans. In the failure to make guns with non-defaceable serial numbers cannot show that manufacturers join both mind and hand with lawbreakers in the manner required for aiding and abetting. This conclusion aligns with PLACA's core purpose. Congress enacted PLACA to halt lawsuits attempting to make gun manufacturers pay for harms resulting from criminal and unlawful misuse of firearms. Mexico's suit closely resembles these lawsuits, and while the predicate exception allows for some such suits to proceed, accepting Mexico's theories would swallow the rule. The court doubts Congress intended to draft such a capricious way out of PLACA, and in fact did not. Justice Kagan delivers an opinion for a unanimous Supreme Court. Holy fuck. LOL. Ah, that's funny. That's pretty funny. Funny joke. Next case. Lord. We turn our attention to Ames versus Ohio Department of Youth Services. Petitioner Marlene Ames, a heterosexual woman, has worked for the Ohio Department of Youth Services in various roles since 2004. In 2019, the agency interviewed Ames for a new management position, but ultimately hired another candidate, a lesbian woman. I hope you've got popcorn, man. The agency subsequently demoted Ames from her role as program administrator and later hired a gay man to fill that role. Ames then filed a lawsuit against the agency under Title VII, alleging that she was denied the management position and demoted because of sexual orientation. In this case, because she was straight. She was discriminated against because she was straight. Yeah, good times. The district court grants summary judgment to the agency, and the Sixth Circuit affirmed. The court below analyzed Ames' claims under McDonnell Douglas Group Corp versus Green, which set forth the traditional framework for evaluating disparate treatment claims that rest on circumstantial evidence. At the first step of the framework, plaintiff must make a prima facie showing the defendant acted with discriminatory motive. Like the district court, the Sixth Circuit held that Ames failed to meet the prima facie burden because she had not shown background circumstances to support the suspicion defendant is that unusual employer who discriminates against the majority. You're going to get wrecked, son. The court reasoned that Ames, a straight woman, was required to make this showing in addition to the usual ones for establishing prima facie. So, because she's straight, she had a pleading burden that a homosexual woman would not have. She's arguing discrimination on the basis of sexual orientation. And the court below said, you can't argue discrimination on the basis of sexual orientation unless you, as a straight woman, make a pleading burden that is not required of a gay person. Doesn't that sound a little bit like the pleading standard itself is discriminatory on the basis of sexual orientation? Yeah. How do you think this is going to play out? Held, the Sixth Circuit background circumstances rule, which requires members of a majority group to satisfy heightened evidentiary standard to prevail in Title VII, cannot be squared with the text of Title VII. No special burden for the straight or the whitey. Straight and whitey does not have a special burden. Title VII's disparate treatment provision bars employers from intentionally discriminating against employees on the basis of race, color, religion, or national origin. For most plaintiffs, the first step of McDonnell-Douglas framework, stating a prima facie cause of discrimination, is not onerous. The Sixth Circuit's background circumstances rules requires plaintiffs who are members of a majority group to bear an additional burden at step one. But the text of Title VII's disparate treatment provision draws no distinctions between majority group and minority. I mean, it literally doesn't. It just simply says discrimination on the basis of sex is illegal. That's all it says. I mean, yeah, basically that is all it says. It's like one sentence long. Title VII is like a sentence. It's literally one sentence long. You know, I mean, yeah, you can't discriminate on the basis of sex and these other criteria. Yeah, so it doesn't matter whether we're discriminating because man or woman. It doesn't matter to gay or straight. It doesn't matter white or black. Yeah, you can, in fact, it turns out, be racist and discriminatory to white people, to straight people, to men or women, as the case may be. Yeah, you can do all those things. This court's precedent reinforced the understanding of the statute and made clear the standard for proving desperate treatment under Title VII does not vary based on whether or not the plaintiff is a member of the majority. See, for example, Griggs. Discriminatory preference for any group, minority or majority, is precisely and only what Congress has prescribed in Title VII. Moreover, the background circumstances rule, which subjects all majority group plaintiffs to the same highly specific evidentiary standard in every case, ignores this court's instruction to avoid inflexible applications of prima facie. Ohio argues that background circumstances rule does not subject majority group plaintiffs to a heightened evidentiary standard, but is rather just another way of asking whether the circumstances surrounding an employment decision, if otherwise unexplained, such the decision was because of the protected characteristic. Ohio's recasting is directly at odds with the Sixth Circuit's description of the background circumstances rule and its application of the rule in this case. Ohio's alternative argument that Ames Title VII's claims would fail even absent background circumstances rule is for the courts below to consider in the first instance. Justice Jackson delivers an opinion for a unanimous Supreme Court. Justice Jackson delivers an opinion for a unanimous Supreme Court holding that, yes, white people can be discriminated against, straight people can be discriminated against, and the standard is exactly the same if they're black or gay. There is no special standard. It's equally illegal either way. Justice Jackson wrote an opinion for a unanimous Supreme Court saying that. Okay. Well, I guess it's that kind of day over here. In SCOTUS land. I'm guessing that the next opinion is also going to be unanimous, seeing as we're 5 for 5. Guessing today, I'm seeing a trend. Here's my Karnak impression. I predict the next opinion will also be beating up on one side and will also be saying that they're stupid and will also be unanimous. That is my prediction. Let's see if I'm. Oh, actually, there's two more. Well, there's just a dismissed as improvidently granted, so that doesn't really count. And Okay, I guess that's the end of the decision. So there is no more. So there's 5 for 5, and then a dismissed is improvidently granted. So that's the end of the decisions. Well, that was intense. That was intense. It was unanimous. It was unanimous beat up on people day. Was there a dissent in the dig? Oh, let me check a look and see if I didn't notice. Was there? Yeah, let me take a look and see if yeah, there was a dissent on the dismissal. Okay, we can read this thing real fast on the dig. So I guess we do have one dissent today. A dismissal and a dig. Did people even get the Karnak reference? Not a chance. Not a chance people get that reference, but that's okay. Justice Kavanaugh dissents from a dismissing as improvidently granted in Laboratory Corporation versus Luke Devas. The court dismisses as improvidently granted, therefore does. Let me mark this thing as well. Mark it. Okay. The court dismisses this case as improvidently granted, therefore does not decide the question presented. Whether a federal court may certify a damages class pursuant to Rule 23 when the class includes both injured and uninjured class members. Feels like a poorly defined class, but okay. The court presumably dismisses this case because the court does not want to tackle the threshold mootness question the plaintiffs have raised. In my view, however, the plaintiff's mootness argument is insubstantial. I rule the case is not moot and would decide the question presented. On the question presented, I would hold the federal court may not certify a damages class that includes both injured and uninjured members. Rule 23 requires commonality. Yeah, I mean, that makes sense to me. How can you have a class that includes uninjured people? Not for the least of reasons is like, what is your cause of action if you haven't been injured? Right? If you haven't been injured, what's your cause of action? What is your standing? It feels like a gimme. Did I see the Greenpeace payout? No, I didn't see that. The facts are fairly straightforward. LabCorp provides diagnostic laboratory services. I got work done by LabCorp today as part of my routine, part of my doctor's routine care. So in 2017, LabCorp introduced self-service kiosks for patients to check in for their appointments, which I use today. Although the touchscreen kiosks are accessible to most patients, blind and visually impaired patients require assistance. To accommodate those patients who cannot use the kiosk without assistance, who prefer not to use one, LabCorp maintained and bolstered its front desk services. I have never seen someone at the front desk of the LabCorp I go in ever. Despite these accommodations, legally blind plaintiffs sued LabCorp in the U.S. District Court for Central District, California. As relevant here, they claim LabCorp's new kiosks violate the ADA and California's whatever, which provides for a minimum of $4,000 in state law damages. Plaintiffs sought to certify a class with potential damages of about $500 million. In May 2022, the district court satisfied the damages class. The class consisted of all legally blind individuals in California who visited a LabCorp patient center in California during the applicable limitations and were denied full and equal enjoyment of goods, services, facilities, privileges, advantages, or accommodation due to LabCorp's failure to make its e-check-in kiosk accessible. Yeah, if they had some other means of checking in, though, that would have been a reasonable accommodation. So that was a failure in the way that they wrote the class. That was a mistake. LabCorp petitioned for immediate interlocutory appeal under the interlocutory rules. LabCorp contended the class definition was overbroad and sweep in uninsured members, including blind patients who would not use the kiosk because they dislike kiosks or prefer to speak with a front desk employee. Again, at the LabCorps the LabCorp I go to, I've never ever seen someone working the front desk, so I'm not sure how that's supposed to work, but never mind. People are too sue happy. No, they're not sue happy. They have a perfect right to their complaint. They have a right to be reasonably accommodated. So that's perfectly fair. But if there was someone there to check them in, that would have been sufficient. So in April 2022, when LabCorp's petition for interlocutory appeal was pending in the Ninth Circuit, District Court clarified the definition. District Court explained the class included all legally blind individuals who, due to disability, were unable to use the kiosk. Importantly, the court stated in refining the class definitions, or does not materially alter the composition of the class. In September 2022, the Ninth Circuit granted LabCorp's petition authorizing interlocutory appeal. After briefing and hearing oral argument, they ultimately approved the class certification. Applying Ninth Circuit precedent, the court reasoned Rule 23 permits class certification even when a class potentially includes more than a de minimis number of uninjured class members. That doesn't make sense to me. After the Ninth Circuit denied rehearing en banc, we sought review. We grant cert. Instead of resolving the question, the court dismisses it. That presumably because the court didn't want to deal with the threat hold mootness. To be clear, the court does not hold the case is moot. Rather, the court simply declines to decide either the mootness question or the important class action question, which would grant cert. Unlike the court, I resolve it. In arguing the case is moot, plaintiffs contend that LabCorp appealed the wrong class certification order. That's incorrect. In May 2022, the district court certified the class, and LabCorp then filed a petition in order to challenge that class certification. The district court then clarified. But in the order, district court stated that did not materially alter. The August order did not purport to certify a new class. The Ninth Circuit subsequently reviewed and ruled on the May certification. The Ninth Circuit did not treat LabCorp's appeal as moot. Yeah. In September 2022, after the district court issued the order, Ninth Circuit authorized LabCorp's Rule 23F interlocutory appeal. Ninth Circuit later addressed the merits with respect to the order. Yeah, I mean, it feels like that would be a basis to appeal regardless of the underlying issue. Still, plaintiffs seem to think the May order was no longer in effect and superseded by the August order. Well, maybe, but why we can't appeal that, I don't know. Under Ninth Circuit precedent, however, they could have appealed the August order because it only provides material change. The order would qualify as appealable. Yeah, blah, 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 blah. So, yeah, I sort of buy that. On the merits, they may not certify damages when, as here, that includes both membered and uninjured. Yeah. Rule 23 authorizes damage only when common questions law. A damage class consisting of both injured and uninjured members does not meet the requirement. They can't, if they're not even injured, they can't share the same injury. Facts. Ninth Circuit nonetheless proved the class. Blah, blah, blah. Ninth Circuit ruling is incorrect. Blah, 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 blah. Yeah, I mean, the Ninth Circuit fucked that up. So I share. It seems like a relatively easy decision to me. So I do share the frustration with Kavanaugh on the issue because it feels like the legal issue is pretty easy, but the Supreme Court decided not to decide after all for whatever reason they made the decision. They could have just not resolved the mootness issue. They could have not resolved it, but whatever. Yeah. I'm a little behind, but did Thomas and Alito put something in the water to SCOTUS to make liberal judges read the law? I know, right? The liberal judges decided for Smith and Wesson in a gun case, in a liability lawsuit against. So Smith and Wesson was sued for money because of the evil guns, and the liberal justices are like, you can't sue Smith and Wesson for money for the guns. A straight woman was discriminated against. And the liberal justices are like, you can't make it harder for the straight woman to sue. I mean, I don't know whether or not today is Kumbaya Day. I don't know whether or not I don't know what we're doing over here. I'm not sure what we're doing over here, but not only were they all unanimous, but they were all pretty pissy unanimous at that. So not only were they all in agreement, they were all in agreement that you're stupid. Yeah. Can I just say, when the Supreme Court 9-0s you on an arms decision, you know that you've lost the plot? Yeah, I mean, yeah. When the Supreme Court decides a gun issue in favor of the gun manufacturer, 9-0, in fairly charged language, I would respectfully suggest. Yeah, you know that not all is well. So, yeah, good times. This also, of course, the issue dealing with the gay versus not gay woman. This also basically means that DEI is just dead because assuming it was unclear before, right? The Supreme Court just gave every employee at every company who is discriminated against because they're straight or because they're white or because they're male. Now you have to prove those things, which can be tricky unto itself, to be sure. But they just gave every employee at every company, basically in the United States, pretty much. I don't think it's literally every company, but it's a lot of them. I forget what the threshold is for Title VII. I forget if it's like 50 employees or something or 30 employees. I'd have to look it up. Doesn't really matter. Almost every company now employees can sue for DEI. Easier than they could have before. So this is like the end of DEI, assuming it wasn't already dead. Because the lawsuits are coming, baby. They are chewing. They are coming. Yeah. Thank you, Scott and Kingslayer, for the super chats. Those were nice. Maybe we're just getting brownie points so they can F us over on a case later. Maybe. I don't know about that, but yeah. Today apparently was fuck you day. I'm struggling to remember like a time in recent memory when you not only had like 5 decisions happen at once, which that sometimes happens this time of year. I'm struggling to think of a time. Not only did you have like 5 decisions happen at once, but all 5 decisions were basically like "fuck you." That's pretty rich. That's pretty rich. All right, I want to talk about watches briefly. Sorry, but we have to talk about my watch habit because. Hold on 1 second, please. Reed's Jewelers has it cheaper. Okay, so maybe I can pick it up cheaper from someone. Yeah, see if I can find it for less because they want to charge me like $42.80 for the watch. But let's talk about this watch really fast because I need to share my unhealthy watch obsession issues. I'll go ahead and tag this as well, just in case. I'll tag this for later. All right, so I went to go and look at this watch today. I went to go look at this watch in the flesh, as it were. This is the Nomos Neomatic 42 millimeter, and it's water resistant to 300 meters, and it's beautiful. And I went to my authorized dealer, and they had ordered one in for me so I could look at it. And I tried it on, and I was like, I really like it. I really like it a lot. It is such a beautiful watch. And it's so pretty. And it fits perfectly. The jeweler I got it from wants $42.80. This jeweler wants $39.60. Presumably they would price match if I asked. Or if not, I could just get it from this company. It's like, will you price match or do I get it from these people? But yeah, it's really, really pretty. It's a beautiful watch. I'm tempted. I have German ancestry. Yeah, so I'm trying to decide whether or not I can afford it, which I really probably can't. But I'm not sure if I'm trying to talk myself into it or out of it right now. But it is a really, really pretty watch. If I were in the courtroom every single day, this would be a watch I could wear every single day with pride, with a suit without any problem. So maybe it's aspirational. I'm thinking about it. It's an in-house movement from a reputable brand. It's very pretty. It's a very nice watch. I don't know if this is an authorized dealer, though. If he's not an authorized dealer, then it's not a fair price comparison. Reads as an authorized watch retailer. So, yeah, apparently it is authorized. Yep. So I should be able to get a price match, I would think. So do I want to spend $4,000 on a watch? Doing a stream with Andrea? That'd be cool. Let's see if she sent me a note. I'd love to do a stream with Andrea. I also kind of want the real version of this watch. This homage version is very nice, but I kind of want the real version too. Although they look 98% the same, so I'm trying to figure out what I'm trying to do exactly. But I'm tempted. Yeah, that watch is an automatic. That watch doesn't have batteries. This watch also doesn't have batteries. And they're both automatic. Buy the watch. I'm thinking about it. If you guys want to super chat me like $4,000, that'd be great. I'm thinking about it though. It is such a pretty watch. I put it on my wrist and I was like, damn. That blue dial is really very, very nice too. The blue is very nice color blue. So it like can kind of do anything a black watch can do too, while also being blue. That shade of blue that they've got going on is a really nice shade of blue. It does everything a black watch does and more. You could wear it. Yeah, it's so pretty. Needs versus wants. Yeah, I know. How many days can I eat ramen in a row? That's what I'm trying to figure out right now. Well, something to think about. Clocks in courtrooms no need to wear. It's not necessarily about the need. You have that tag in pink? Nice. Is that a chrono that you've got, Jan? Do you have a tag? Do you have a tag chronograph in pink? Yeah, it's a chrono. Nice. Nice. Excellent. Tudor makes some really good looking chronos too, if I don't say. Hamilton also has some chronographs that are really cool looking. Well, in any case, I think I'm going to go ahead and sign off. Thanks for joining me for Supreme Court Day. We'll be on tomorrow with more Karen Reed. Karen Reed has said that they're looking to rest their case on Tuesday-ish, give or take, which sounds vaguely correct. 3 more days of testimony? That sounds vaguely correct. So, yeah, they're looking to rest on Tuesday, give or take. And then, of course, the state gets a rebuttal case, which I imagine that they'll take advantage of. And how long that will take, who knows? It probably takes a day at least, maybe more. Yeah, maybe they charge the jury on Friday. And maybe we get a decision on Friday too. I should get to watch. I really should. All right, I'm thinking about it. I really should. Yeah. And just Rhonda, I hope you like the watch that I picked for you. And if you don't like it, you can always return it and get something else. But I hope you like it. So yeah, I thought it would go much later. They said 10 days, right? They said 10 days. When did the defense take over the case? Was it Monday? Yeah. So it looks like it's shorter than they predicted. State rested on Thursday? Okay. So they had Friday. So they had Thursday. They had part of Thursday, Friday, Monday, Tuesday, Wednesday, Friday. So that's 5 days. Then Monday, Tuesday is 6, 7. So they're basically on target. They said about 10 days, and they're looking at 7 days for the defense case. Yeah, okay. That makes sense. Yeah, okay. So about 7 days for a defense case. All right, cool. Am I happy with the watches I already have? In a lot of ways, I am. I mean, of course, I've got a Rolex Submariner, and you can never go wrong with that. I mean, that watch is timeless. You know, that watch is timeless. So if I needed a nice watch to wear with a suit in court, I just wear the Rolex. It's a little, it's a little basic, but it's a little basic bitch, but it's it's a Rolex Submariner, so there's nothing to say about it, right? Except it's a Rolex Submariner, so it's like, you know, so I don't really need it. Not even for court. I don't really need it because I could just wear the Rolex and call it a day. I don't even really strictly need it for court. I mean, I could wear anything with court. No one would notice except me. I could wear anything with court and no one would notice. Arca's not testified? Yes, they did. I think one of them did testify. Did Arca testify or not? Or was it just the data expert guy? Yeah, I'm confused whether Arca testified. Yeah, I'm losing the plot a little. Things are blending together. I'm losing the plot. If you call Rolex a basic bitch, you're in a different class of watches than me. Fair. Very fair. Yeah, of course you don't have to wear a watch to court at all. That's also true. You don't have to wear a watch at all. That is very true. I'll see you guys tomorrow. Have a good one. Bye.